Right friends, welcome back to editorial discussion. And the first most important aspect, there are several articles with regard to the Supreme Court judgment on Triple Talaq, instant Triple Talaq you can say. This goes on various provisions of constitution. My lecture basically on the following lines, various provisions of constitution. Second thing is, what is the judgment of all the 5 judges? That means there are 3 viewpoints. Next one is, what are the practices in Muslims in our country? Next one is, what is its fallout? And the next one is, what about the religious practices in other religions? Then finally, is it not judicial overreach? So all these aspects we are going to deliberate. So there are several articles yesterday and today in the Hindu and Mint, Indian Express. If you club all together, I can come to this part of lecture. Here you see article 14 says, discrimination on the grounds of religion or race or caste or sex or place of birth is prohibited. The state shall not deny to any person equality before law. So here, based on this, gender justice comes into picture. So the gender justice primarily emanates from equality before the law. And at the same time, article 13(1) also you should not forget. That means laws inconsistent with fundamental rights are void. You see, all the laws in the force in the territory of India immediately before the commencement of the constitution or any law made subsequent to the constitution came into force, if they are inconsistent with the fundamental rights, that is null and void. So article 13(1) you should not forget, article 14 you should not forget, and article 25(1). This is the right to practice religion. So in our country, as per the constitution, all the religions are given the right to freely profess, practice and propagate religion. So these 3 are very, very important. Overall, if you see the judgment, it revolves around these 3 articles of the constitution. Article 13(1), it gives inconsistency with regard to the laws, and article 14 which says equality before law, or you can say gender justice and right to practice any religion in this country, that is also guaranteed in the constitution. So if you look at these things, let us look at the news report first, then I am going to deliberate the basic view of majority, the view of minority. From examination perspective, you should have clear idea about this judgment, because there are 3 different views in the judgment, not 2. There are 3 different views in the judgment. And here see, as per the majority judgment by the multi-faith constitution bench, here in fact all the 5 judges belong to different religions, and instant triple talaq was called manifestly arbitrary practice, and it is not protected under article 25 of the constitution, and article 25 gives freedom of religion, as we have already seen, and it is in fact arbitrary and violates article 14, which is right to equality. So it is between article 25 and article 14. The majority judgment has gone for article 14, right? Then you see 5 judges belonging to 5 different faiths. The minority view taken by the Chief Justice as well as Justice Abdul Nazir, it says that talaq-e-bidat. I am going to explain what are 3 practices of talaq, out of which one is talaq-e-bidat, and the Chief Justice says that as per Muslim personal law, it is an integral part of article 25, or you can say the Chief Justice along with Justice Abdul Nazir has voted for article 25, whereas the majority judgment has gone for Article 14. So, this is all about this judgment, and the Chief Justice says that it is in vogue for over 1400 years and it made instant talaq a matter of religious faith which cannot be tested under the touchstone of Article 14. Personal laws must be an exception to the Constitution's aim to protect gender equality. Article 14 says gender equality. Article 25 says freedom of religion. Chief Justice along with another judge voted for Article 25, whereas the majority judges voted for Article 14. So, you can say this is the clash between Article 14 and 25. Majority judgment. In the majority judgment, you can see two judges felt from different perspective in comparison to Justice Kurian Joseph. In the views of the two judges, Sharia law was statutorily incorporated by the Muslim Personal Law Act of 1937 and hence triple talaq is a statutory right but not a fundamental right. They stated it is as per 1937 Act. So, therefore, it is a statutory right but not a fundamental right which is guaranteed as per the Constitution. So, all the laws enacted by the legislature must be in conformity with the Constitution, but in this case, this Sharia law of Act of 1937 is a statutory law, or you can say statutory right, but not a fundamental right which is guaranteed by the Constitution. So, here the two judges felt that Section 2 which enforces triple talaq is arbitrary, and the view of Kurian Joseph, he felt on different lines. What he thought? Instant triple talaq is against the tenets of Quran and it is not part of Sharia law. Islam cannot be anti-Quran. This is the view expressed by Justice Kurian Joseph. These two judges felt that this fundamental rights must have supremacy over the statutory laws, but altogether different view is taken by Justice Kurian Joseph. In the words of Kurian Joseph, Islam cannot be anti-Quran and this triple talaq, instant triple talaq is against the tenets of Quran. So, the viewpoint is different among these three judges also, but it pointed to that this cannot be a law, that means this cannot be enforced. The two judges felt that it violates fundamental rights and this judge felt that it is against Quran, right. Overall, finally, they told that it is invalid. And what is the opinion of minority judgment? Chief Justice J.S. Kehar, Abdul Nazir on the other side, what they told? Triple talaq is discriminatory. The Chief Justice felt triple talaq is discriminatory, but it is to be protected by freedom of religion in the Constitution, Article 25. So, it is to be protected under Article 25. Chief Justice invoked extraordinary powers of Supreme Court. What the Chief Justice said? Let us use extraordinary powers of Article 142, which has got extraordinary powers to Supreme Court, and here let us give injunction to the Muslim husbands not to use this for 6 months, and let us give 6 months time to Parliament so as to take legislative decision in this regard. So, this is the view expressed by minority judgment, but now this invocation of Article 142 will not hold good because majority view prevails over the minority view. That is important point to note, right. Main view of Chief Justice of India Kehar, you should put some thought process into the view of Kehar, though it is minority judgment. You see, because tomorrow some more religious practices may come to the doorstep of Supreme Court, but Chief Justice Kehar said that apprehensions about the inroads into other personal law practices, he advised judges to exercise absolute restraint. In his viewpoint, it is not advisable for judicial activism in matters of religious faith. In his viewpoint, this may not stop here. Tomorrow, more and more religious practices may come to the doorstep of Supreme Court. So, let judges exercise restraint. Let it be left to the legislative processes. So, let us not take activism in religious practices. That is the viewpoint of Keha. A call of conscience may have a cascading effect, and here our conscience may go into the hook and nook of religious practices and personal laws. There will not be any end. He also stated that the court, based on a righteous endeavor, if you think on rational lines, several faiths of various communities can be questioned. There are several faiths pertaining to the various religions. They can also come to the doorstep tomorrow. And if we use the rational approach, tomorrow we may be in the difficult terrain, because religion is integral part of Indian society and culture. That is the viewpoint of CJI. The Constitution assures believers of all faiths and their ways of life is guaranteed and would not be subjected to any challenge. He observed that court of law has got limited jurisdiction in the matters of faith. Right. There are three forms of divorce. If you come back to the Muslim practices, there are three forms of divorce, and not only these three forms of divorce, there are two more words which you often come across. One is polygamy and the other one is nikah halala. So, these five are basically in the news in recent times. If you see three forms of divorce, this what the Supreme Court declared not, that means it is against the article number 14. Finally, as per the majority view, here this talaq-i-bidat. So, this is instant talaq, that means 3 times uttering the talaq, which means it is a divorce straight away. So, the Supreme Court ruled on this. There are two other practices of Muslims. Supreme Court has not looked at those two things. Here you see talaq-i-ahsan, another one is talaq-i-hasan. Here husband gives talaq to wife in state of purity, and he waits for iddat period. In the iddat period, then there is a possibility of revocation between husband and wife. So, that is talaq-i-ahsan. So, in the iddat period, this divorce can be revoked, and after iddat it becomes irrevocable. That is important point. And here you see talaq-i-hasan. So, this practice is basically 3 successive pronouncements of talaq, and in between these successive pronouncements, there must be one menstrual cycle of the woman. So, or you can say there may be an interval of around 30 days of pronouncing talaq, and time is given, again one more talaq, again time is given. So, like this is talaq-i-hasan. So, this can be revoked during any time before the third time pronouncement. So, here the first one is there is possibility of revocation during the iddat period, and in the second case during monthly time, or you can say menstrual cycle time, normally 28 days for women. So, 28 days. So, there is a possibility for rapprochement within the next 2 months, right. So, here talaq-i-bidat pronouncements can be made during a single time. That means, if thrice it is stated, then it becomes irrevocable immediately when it is pronounced, irrespective of iddat period. So, now Supreme Court talked about this. There are 2 more practices. One is polygamy. Polygamy means husband having more number of wives. One more is nikah halala. Nikah halala is revocation is possible only after divorce. The woman has to remarry, and again she has to give divorce. So, these 5 practices are in the news in recent times. Now, Supreme Court ruled about talaq-i-bidat. Don't forget. What can be its fallout? Let us take it from 2-3 perspectives. What can be its fallout? Muslim organizations may fear that it may lead to uniform civil code, which will have its own consequences on India's multi-religious social structure. India has got multi-religious, multi-customs, multi-cultures, and gradually with this judgment, Muslim organizations are expressing fear that government may push for uniform civil code. I am not going into positives or negatives, but I am explaining here the fallout of this case. Second one is Section 377 of Indian Penal Code, which criminalizes homosexuality, and this may come under spotlight. Another important aspect is there may also be demands for making legal marital rape. That means here there may be demands with regard to the legality or illegality of marital rape. This may come under spotlight. Then it may further focus on the other religious practices of various other communities, right. So, here this may be the fallout, and here you see there may be demands with regard to the marital rape, and this is also in question in recent times. Then what about other religious practices? And if you see from the broader perspective, other religious practices may also come into spotlight. And here you see Christian women could not obtain divorce on the grounds of adultery committed by the husband. If the husband has got some illegal relationship, Christian women could not obtain divorce simply, and it had to be coupled with cruelty, sodomy, and all other aspects. And on the other hand, Christian husbands could simply declare their wives if they have relationship with some other person. So, there are in fact inconsistent laws. If you look at other one, that is Parsi daughters. If Parsi daughters marries non-Parsi men, they lose their property rights. This is another inconsistency, and there may be demands for amending the Christian Divorce Act of 1869, and I have listed only few inconsistencies like that. There may be several inconsistencies in other religions also, and they may come under spotlight in future, right. Then is it not a case of judicial overreach? Here the fundamental question is whether it is in the court's domain to discard or uphold a religious practice. And here you see in the judgment also, judges deliberated more on religious practice than gender equality. Most important aspect is judges have deliberated a lot about this religious rules and regulations or customs than this gender equality. Here the issue of the Muslim woman is basically pertaining to gender equality if you look at it from different perspective, but the judges have gone more into the religious practices, and that may open Pandora's box in our country. So, here the fundamental question is whether it is the court's domain to discard or uphold a religious practice. So, from this judgment it is evident that court can pick up any religious practice. Now, it is possible courts can pick up any religious practice, either it is pertaining to Hindus, Christians, Muslims, whatever the religion, and check if it forms an essential part of religion, and if not, hold it impermissible. The court can find a practice to be an integral part of religion, but still it may prevent individuals from practicing it, and it may direct the government to legislate on certain practices. So, it opened in fact Pandora's box, or you can say it may open Pandora's box. The personal laws of other religions may also come under scrutiny in future. So, these aspects one should not forget. The court merely acted as a reformer of a religious community rather than upholding the fundamental rights of women as per the conclusion in the Hindu. And in fact, in the judgment also you can see most of the times the judgment talked about the religious practices, and it talked less about the fundamental rights of women or gender equality. right friends. There will be no end if you go on discussing on these aspects, and I hope that I discussed this important aspect in a more rational way, putting forth all the pros and cons of the judgment. Right friends, we discussed articles today. Please stay with Learning Space. Have a nice day. Thank you.